What happens when a defendant walks into a criminal courtroom convinced the legal system is actually a financial institution, and that filing equity paperwork can somehow override felony charges? In today's Courtroom Showdown, we watch a judge attempt to conduct a routine hearing to determine whether the defendant can legally represent herself. But instead of straightforward answers, the courtroom spirals into a maze of estate claims, equity doctrines, commercial demands, and sovereign-style legal arguments that have absolutely no place in a felony prosecution. At first, the judge gives her every opportunity to clarify her position, carefully explaining the rights she would be waiving, and the serious prison time she could face if convicted. But the deeper this hearing goes, the clearer it becomes that this defendant isn't trying to prepare a legal defense. She's trying to force the court to operate under rules that simply do not exist in criminal law. This is where things get fascinating, because judges are required to protect a defendant's constitutional right to self-representation, but they are not required to let someone hijack proceedings with pseudo-legal theories that disrupt the court. The tension rises minute by minute as the judge tries to separate real law from fantasy, and by the end, he makes a decisive ruling that shuts the whole strategy down. The real question is this: was this woman genuinely confused, or was this an intentional attempt to derail the case? Watch closely, because the judge's final ruling may answer that for all of us.
Let me know when I can.
Go ahead.
When we spoke earlier about the document that was submitted, I just want to inform you that the head clerk is aware of it. Since May 11th, they've been working with me, providing me all the accounting. What you just gotten just now, I think one of your staff did not follow the correct procedures. So I was going to let you know that my estate has not been abandoned. I also want to let you know that I did not appoint anyone to administrate my estate. So, for that being said, I'm coming here with honor, clean hands, and no controversy. I do not want to argue about anything. I just want it to be settled, closed, and gone.
Okay, ma'am. Anything else?
When you do present another date for me to come in, would I be able to talk about this matter? How this all led up to, because I really never got a chance to even speak to no one. I've been
Ma'am,
silent.
that's what the jury trial's for, okay? All the facts and circumstances related to the case, the state's evidence, everything of that nature would come out during the jury trial. So I need to go through this Feretta hearing with you, ma'am.
Okay.
You've indicated you want to represent yourself at trial. You have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range?
Right here, the judge is doing something extremely important. He's creating a legal record proving that the defendant fully understands the risks of representing herself. This is called a Feretta hearing, and its entire purpose is to make sure the defendant knowingly and voluntarily waives the right to an attorney. Notice how carefully the judge explains the sentencing exposure, the benefits of trained legal counsel, and the dangers of going to trial alone. That isn't just courtesy, it's constitutional protection. The defendant is facing 2 level 6 felonies, meaning real prison exposure, and the judge is spelling out exactly how an attorney could help reduce sentencing, challenge evidence, and preserve appellate rights. If she chooses self-representation after hearing all this, she owns that decision. But something else is happening here. While the judge is focused on criminal procedure, the defendant keeps hinting at estate issues and accounting. signaling she may be operating under a false legal framework. That's a major red flag, because if the court believes a defendant does not actually understand the legal system she's entering, then the right to self-representation can be denied. So what do you think? Is she making an informed decision? Or is she stepping into a felony case with a completely flawed understanding of the law?
And select a jury. They have the training, knowledge, and skill at properly preserving the record of the case for purposes of an appeal. An attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close,
Yes.
different things like this.
Yes.
And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that I had ended up
That's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand
Yes,
that?
yes, I am in a criminal proceeding, but like I've been trying to explain ever since when I had.
Well, I need you to answer the question I asked you.
Okay.
Okay, which was whether you understand that these documents and things that you follow with the clerk's office, what's the receipt date on this?
It should be April 16th or 15th.
April 16th it was received, so just yesterday.
Mm-hmm.
That these aren't criminal matters that you followed with the court?
Mm-hmm. Those are criminal matters, the violations that have been held against me. Yes, that's a lot of violations.
You understand they're not, though. I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
some
that's
sort of a pseudo legal jargon, some type of a.
This is the turning point where the judge realizes this isn't just confusion. It's a collision between actual criminal law and pseudo-legal ideology. The defendant keeps referring to equity, administrative mistakes, and banking systems, but the judge is trying to make one thing crystal clear. Criminal courts do not operate like private financial institutions. These kinds of arguments often come from online misinformation claiming courts are secretly commercial entities and criminal charges are merely contractual disputes. But that theory collapses immediately in a real courtroom, because criminal law is based on statutory authority, not consent, contracts, or private equity doctrines. The judge is staying remarkably patient here. He's giving her multiple chances to confirm she understands that Indiana criminal procedure, not personal interpretations of commercial law, governs this case. Why does that matter? Because if she insists on defending herself based on invalid legal concepts, the court has to consider whether allowing self-representation would undermine the integrity of the proceedings. At this point, the judge is no longer evaluating her intelligence. He's evaluating her capacity to follow courtroom rules. And if that answer is no, the right to represent herself may disappear very quickly.
My documents, the evidence held against me, and he refused to present them to me. That's a brand new violation because it worked in my favor when I first got it. Then also
Ms.
on the
Butler,
record.
I'm trying to get you through this
Hold on.
Feretta hearing.
I know, but you asked me, and I'm trying to explain the violations, okay?
Right, but those aren't violations that are
They are.
part of this court proceeding.
Now, on this court proceeding.
If you have something that you plan to file related to that, it has to be filed through your attorney because you
And
still have an attorney.
I did that too. You know what he did?
I don't know, man.
Ignored me.
What you have filed through the clerk's office you're saying are matters in equity, we don't recognize what you're talking about in
You
these
guys
filings.
this is a bank. This is a bank. I understand how the
What'd you say?
this court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system doesn't
operates.
operate like a
Yes,
bank
it
in any way whatsoever.
hold on, let me finish.
No, I'm not gonna let you finish that
Okay.
particular
Like I
statement.
said, I want to
because
preface
I
this.
just
Don't
need-
want to argue.
I need you
anything.
to,
I just want you to
redirect it.
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay.
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is a criminal court.
Yes, it is. This setting is.
We're not an Article 3 court. That's a federal concept.
Yes.
You understand that?
Yes, I am.
Okay, we're an Article 7 court, if you must know, in the state of Indiana, separate judicial branch,
Yes.
not any of the things that you've said here.
Yes.
So what I need you to tell me is
Okay.
whether you are understanding that you have to follow, if you're going to represent yourself, you have to follow all the rules and regulations that are promulgated by the courts of Indiana. You have to follow the criminal rules. You have to follow the trial rules.
And here it
Yes.
is, the moment the judge reaches the legal conclusion that changes everything. After listening to the defendant double down on equity, living estate arguments, scriptural authority, and commercial claims, the judge finds that this is not a genuine legal defense strategy, but an effort to obstruct the proceedings. That distinction matters. Under the Constitution, defendants absolutely have the right to represent themselves, but that right is not unlimited. Courts can deny self-representation when a defendant demonstrates that they are unwilling to follow procedural rules or intends to use the courtroom as a platform for disruption. That's exactly what the judge is saying here. He's making formal findings that her filings are legally irrelevant, that her arguments are rooted in sovereign-style rhetoric, and that granting her request would interfere with the administration of justice. This is a textbook example of a court protecting due process, not taking rights away. And honestly, this is why legal reality matters. Believing internet legal myths can cost defendants real opportunities to defend themselves. Instead of moving toward trial preparation, this defendant just lost control of her own case because she insisted on arguing fantasy over fact.
No, I don't understand.
Okay.
How you
You
just
have
lost track.
filed documents making commercial demands, demanding accountings,
Yes.
challenging the capitalization. No, you didn't do that, but challenging different things about who you are and who you would in equity
Yes.
minister to,
And for
those
me,
kinds of things. Ma'am, you understand those have no basis in Indiana criminal law.
okay.
You realize
But-
that?
But let me explain. Can I make a statement to you then? You said there's no basis in criminal
Go
law.
ahead. What's your statement?
Well, I also want to say something. And I also am a minister, and I want to read this on the record, okay? And it states that should a man prove himself to be living and not dead, nor lost of sea, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executive. As such, this office give notice of its accusations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executive. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon it and administrating it. I discovered a lot of things along the way, put me in this position.
This hearing ended with one of the clearest lessons you'll ever see in a courtroom. Self-representation is a constitutional right, but it is not a free pass to ignore the law. The judge gave this defendant every opportunity to demonstrate that she understood the legal system, the charges against her, and the rules she would need to follow. Instead, she repeatedly relied on pseudo-legal theories involving equity, commercial claims, and estate administration. concepts that have no legal force in a felony criminal prosecution. Because of that, the judge ruled that her request to represent herself was not made in good faith and was instead a deliberate attempt to disrupt the proceedings. That ruling kept appointed counsel on the case, ensuring that the trial process stays grounded in real law rather than legal fiction. This case is a powerful reminder that courtroom arguments must be based on recognized law, not internet theories. The justice system allows defendants to defend themselves, but only if they are willing to operate within the rules that govern everyone. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.